AI Act, relief or nuisance. The road to the world's first specific legislation on regulating safety of AI have been a winding one. Welcome to today's event on the AI Act in practice, where you will have the opportunity to listen to two exciting speakers with two completely different outlooks on how the AI Act will affect them directly. One from the regulatory side with an agency perspective, the other from the commercial side from a business perspective. After this, we'll move on to a panel discussion with 4 panelists, all with a unique frame of reference on the challenges they will meet in their day-to-day business.
It's time to introduce our first speaker, Per Nydén, a legal specialist in AI and innovation at the Swedish authority, IMI, with a deep understanding of the legal landscape surrounding artificial intelligence. Per is an expert in navigating the complexities of AI regulation and GDPR. One of his areas of focus is the regulatory sandbox, where legal and technology meets and AI can be investigated. It's worth mention that AI Sweden has been actively involved in this project and collaborative efforts across sectors to address the regulatory challenges posed by AI innovation. With this knowledge and forward-thinking perspective, Per will offer valuable insights into the evolving regulatory landscape surrounding AI. So welcome our first speaker, Per.
Thank you so much, Tilde and Belly and AI Sweden for having me today. It's a great pleasure being here. So my name is Per Nydén and I'm a legal counsel at IMI. And I'm also coordinator for IMI's Innovation Center or Innovation Hub. And at the Innovation Hub, we do many different things, but maybe the most exciting and intriguing thing that we do is that we run a regulatory sandbox for data protection. In addition to this, I'm also responsible for following and analyzing what impact the AI Act will have for our organization, as well as preparing us as much as possible, which is of course a super fun and exciting work task. So the AI Act, what is that? Some of you who are listening in today are probably very well familiar and well versed in what this act will imply for your own organization, while others might not be as acquainted at all at this point. I have now almost 10 minutes more or less at my disposal for this section, and of course I won't be able to provide you with an in-depth analysis or guidance, but I will briefly discuss what it entails, and particularly focusing on the role IMI is likely to play according to the AI Act. So the AI Act is indeed a comprehensive regulatory framework. In the latest version that I've seen myself, it contains 113 articles, and that is actually more than the GDPR, which only contains 99 articles. So it is indeed a comprehensive regulation. You have probably heard that the AI Act divides AI systems into different risk categories, from AI systems that are to be banned on the European market to those systems that are deemed low risk and to which the AI Act won't pose any new legal requirements. The AI Act primarily targets what are known as high-risk AI systems, and in short, the regulation implies that such high-risk AI systems that they must be CE marked before they can actually be released and placed on the European market. But in order for a provider of an AI system to actually be legally allowed to put CE marking on that product or on that system, well, then it must first ensure that the system meets certain requirements, both organizational and technical requirements, which are set out in the AI Act. So how do you know then if an AI system is considered as a high-risk AI system? Well, most of them, but not all, but most of them are listed in a specific annex to the AI Act. And that list is already quite long, but it will probably get even longer over time since the EU Commission can, under certain circumstances, add new AI systems to that list. And currently, this list, which is set out in the annex, is divided into 8 distinct categories. And on the slide here, you can only see, I've only written the heading of each and every category, but in the actual annex, you can also find the various AI systems listed under each and every category. For instance, under point 6 here in relation to law enforcement, you'll find, for instance, AI-based lie detectors used by law enforcement authorities, such as the police. That is one example of an high-risk AI system, but that's just one of many. And just like any other regulation, there will be an authority that is responsible for ensuring that organization also comply with the AI Act, and that also has the mandate or power to impose sanctions otherwise. And the supervisory landscape in this context is quite complex, actually, because according to the AI Act, the supervisory responsibility will be divided between several existing authorities. And in Sweden, this includes, for instance, the Swedish Medical Products Agency, that is Läkemedelsverket, and the Swedish Work Environment Authority, Arbetsmiljöverket, but also IMI, that is the Swedish Data Protection Authority, and that is only to mention a few of all other relevant authorities. So which area will IMI then supervise? Well, most likely IMI will be responsible for supervising high-risk AI systems deployed by law enforcement authorities, but also migration control authorities. And if you look at this slide, is exactly the same slide as I previously showed, but this time on this slide, I have also highlighted all the categories of high-risk AI system that will likely fall within IMI's area of supervision or responsibility. And as you can see, half of them, or actually 4 out of 8, are highlighted here. So in practice, the AI Act will entail quite a comprehensive task for us as a data protection authority. And the AI Act has not yet been adopted, but it is expected to be that very soon or anytime soon. And after it has been adopted, then the rules covering high-risk AI systems will not start to apply until 2 years later, which may seem like a long time, but as we all know, time flies, and there is quite a lot that must be put in place in order for organizations to actually live up and comply with this regulation. So my recommendation is to already start looking into what will this mean? What will this AI Act imply for my own organization? It's simply about getting acquainted with the AI Act as soon as possible. Furthermore, I do recommend that you make an inventory of those high-risk AI systems that you use today or deploy today within your own organization, and also assess what kind of systems do we believe that we will use in the future, in the near future. Will you develop your own AI systems, or will you only purchase existing AI systems that are available on the market? Because different rules under the AI Act will apply provided whether you're what kind of operator you are, if you are actually a provider or a creator of an AI system, or if you're only a deployer, then different rules would apply depending on what kind of operator you are under the AI Act. One thing to keep in mind, that is that the GDPR will be applicable alongside the AI Act. So the AI Act does not provide any exemptions from the GDPR. And this is something we get many questions about. And on that topic, one might get the impression that AI today is an unregulated technology, and that is, of course, not true. AI is not a new technology in itself, and the GDPR, that still applies to any form of personal data processing, regardless of whether that processing is made or done through an AI system or any other form of technology for that matter. If you already have a functioning compliance system as regards your personal data processing today in place, well, then I don't think that the requirements set out in the AI Act will be that challenging actually to manage. It is then more about incorporating another layer of compliance task on top of your already existing or current compliance system. But however, if you have not done your homework properly when it comes to the GDPR, then I do believe that the AI Act also could be perceived as a complex regulatory framework that requires quite some effort from your organization. One of the purposes of the AI Act is that AI systems that are created and developed on the European market, that it's human-centric and trustworthy. And we at EMI, we also believe that it's fully possible to combine innovation with privacy protection. And we are convinced that these two interests are compatible with one another. Although the supervision of the AI will be distinguished or distributed among many different national authorities, as I mentioned earlier, the AI Act also stipulates that in each and every member state, there shall be one authority that has the overall responsibility for the AI Act. So which authority will that be then here in Sweden? This is also a question we get quite often. Well, the fact is that we don't know yet, so that still remains to be seen. However, we at EMI, we have raised our hands and we have publicly announced that we are willing to take on that task. We have assessed that we are well prepared to undertake such an assignment. And what are the arguments for that then? Well, there are several, but among other things, we believe that it would facilitate matters for both private and public actors if issues relating to AI and data protection would be dealt with under one roof. Furthermore, we are used to providing guidance on complex technology and the law, because as mentioned earlier, AI is not unregulated today. The GDPR has been applicable to AI system processing personal data since this regulation entered into force. And therefore also AI is a technology that we are already familiar with at EMI. Thank you so much for listening to me. It's been a great pleasure being here, and you will also hear from me soon as I will be joining the panel discussions later. So thank you.
It has been time to introduce the next speaker, Patrick Geyer, the head of global affairs at Europe's largest private AI lab, Silo AI. With a rich background in driving global partnership and leading innovative projects, Patrick is at the forefront of shaping the future of AI technology. Patrick will explore the finer details of business implementation in the AI landscape. With his experience in the field, he will share invaluable insights and hands-on tips, offering a roadmap for success. From practical advice to strategic guidance, Patrick will give us some key takeaways. While Patrick may not be a legal expert himself, his strategic perspective and deep industry knowledge make him a valuable contributor to this discussion. So, welcome our second speaker, Patrick.
Thank you so much, and good afternoon, everyone. It's a real pleasure to be here, and thank you very much, Pat. That was a great introduction to I think what's been probably yours and mine collective hobby for the last year or two, and likely for the upcoming years as well, which is of course the AI Act. So to start off, you know, I'll focus on more sort of how companies should approach the AI Act or could approach the AI Act. But I do want to start off with some caveats to this process as well. You know, every company, every use case is of course a little bit different. Any list like the one I'll be providing with you for you today will of course not be 100% exhaustive and cover all the angles. So I do implore you all to do what Pat also said, which is to really familiarize yourselves with the AI Act and with subsequent rules and details that are still to come over the coming years. Additionally, my talk will include a lot of opinions that are sort of based on my personal background, and also my experience working currently for an AI company, but previously for other technology companies. But ultimately, it is, of course, up to you and your organization to make the decisions on how you decide to approach the AI Act. So I'll focus mainly on some top-level strategic considerations, and then later on jump in a little bit more to the sort of tactical level to try to provide some hands-on guidance on how to approach the AI Act. Starting off with the more strategic considerations for you and your organization. As we heard from Pat, the AI Act is a very broad regulatory framework. The surface area, impact area is wide, and almost every company is likely in scope in one way or another. However, that doesn't necessarily mean that you and your organization will actually have to do a whole lot to be compliant, but I do implore everyone to familiarize themselves because the surface area is extremely wide. Additionally, it's of course the first time also, as Pat mentioned, that AI is holistically regulated as a technology, and therefore there are a lot of gray areas. I would want to, however, also echo the previous speaker's comments that it's not like AI has been a Wild West so far. In addition to the GDPR, there are a lot of sector-specific rules in anything from medicine to energy to consumer goods that relate to how you are allowed to use technology, which also has direct and indirect impacts on how you can use AI in these technologies. So it's not like we're starting from zero here. Anyway, these four strategic considerations here is sort of a summary, and I'll dive in a little bit deeper into each one of them. One key word that sort of summarizes them all, perhaps, is agility. So let's stay agile and move forward. So my first tip is to adopt a risk management approach. Don't panic, don't overdo it. Let me open up a little bit what I mean by each of these comments. As I said, it's the first AI law of its kind, not just in Europe, but globally. We are really at the sort of frontier, not just of a technology like artificial intelligence, but also in terms of how you regulate it and how policies around it are formed. Nobody really knows exactly what this regulation and the enforcement of it ultimately will end up looking like. There are a lot of people, very, very smart people on both the authority side and on sort of in law firms and inside of companies thinking about these things. But ultimately, no one knows exactly what a perfectly compliant company will look like. Some things will become clear over the next months, years, as some of these rules enter into force and we receive more technical guidance. But however, it is good to sort of be mentally prepared that there will likely not be answers to every single question. It's not a binary proposition if you are compliant or you're not compliant. And I think that's a very important mindset to take. It's not black and white. There will inevitably be a lot of gray areas that might not become clear, inside of a few years or even after that, perhaps until, ultimately the European Court of Justice or local courts, have their say in some of the details. And this applies to everything from the, definitions of things like general purpose, artificial intelligence, a lot of other definitions that for the first time are legally defined in this act. So it is frankly impossible for anyone to know exactly how this will play out. However, this might sound a little scary. So to go to sort of the other side of the headline, don't panic. There's still a lot of technical legal guidance, technical standards and things like this that will come out over the coming years. So there will be more clarity compared to the situation we have today. Agencies such as PAS will work diligently over the next years to also provide help, engage in stakeholder dialogues like this one and provide clarity through these means. Hopefully, regulators, enforcers will also have some understanding in the beginning as everybody figures this regulation out together. And I very strongly believe and I'm confident that good faith efforts on the side of companies to be compliant will go a long way. So if you approach this honestly, dutifully, I do believe that will go a long way. Then to the point about don't overdoing it. Compliance is, of course, extremely important, but it's also extremely expensive and can be very cumbersome and very complicated. And this is sort of my somewhat clumsy bridge to my next slide. So learn from, for example, GDPR compliance and leverage existing frameworks that you have. Now, the connection to the previous point I mentioned about don't overdoing it is that in my personal opinion, practically all companies, all organizations went through some form of compliance, internal compliance process related to the GDPR, the General Data Protection Regulation. There are stakeholders inside of your organization that will very likely be, depending a little bit on your role, inside of the AI Act framework. But a lot of these stakeholders will very likely be the same ones that you'll have to engage with, excuse me, in terms of the AI Act. And GDPR compliance, the same processes you adopted internally, can serve as a good template for AI Act compliance. However, the connection to the point about don't overdoing it, and I want to be really clear that this is sort of a personal opinion here, but I worked as a consultant back in the day when GDPR entered into force, and I did see how stressful and cumbersome that process was for a lot of companies. And personally, I believe that a lot of companies and organizations probably went a little overboard in terms of preparing for GDPR compliance. Now, what do I mean by going overboard? I mean that, a lot of time, effort, and money was spent in working groups internally. A lot of money was spent on external experts. A lot of collective resources were used. And ultimately, looking at the GDPR now, with some years of experience, what ended up happening was that actually very, very few organizations were targeted with fines. And before fines actually ended up materializing, usually there was a lot of discussion with the local data protection authorities and other authorities involved, and solutions were sort of hatched together. So if you felt like your organization spent a lot of resources on GDPR compliance, that might be and sort of too many resources on that might be a good lesson to keep in mind as you prepare for the AI Act. Now, the third strategic consideration I'd suggest is to monitor regulatory evolution and to be agile. That's as a starting point for your internal preparation, your internal orientation around the AI Act. It's really crucial to understand where we are now in the process, what happens next, and what the timeline is on the policy and the regulatory side. So this is a very broad timeline looking at, this is by no means exhaustive and does not include all the little details, but we are about at that point between the sort of lighter blue and the darker blue, where, we've seen the final text that's gone through what's called the lawyer-linguist process inside the European Commission. But as the previous speaker mentioned, we don't yet have a formally adopted version of the AI Act. That will likely happen in about a month's time. And from there on, sort of the clock starts. And that's where, you see the darker blue boxes on the right side. That's when the clock will start ticking for the 6 months, 12 months, and 24 months. Now, during this period of 2 years, there will be numerous pieces of what's called secondary legislation, so implementing and delegated acts, technical standards, legal guidance of different kind that will be developed, adopted, and ultimately published. National enforcement bodies, as Pat said, have not been decided yet in member states, and the AI office, which will function sort of as a supranational coordinating body, under the European Commission, and will also have some direct regulatory authority. They have not, that has not been staffed yet. It's not even formally founded yet. You'll see a lot of work, as I said, on standardization, but also on different codes of practice and similar documents, depending again a little bit on your role in this framework. And so my message here is that we don't yet know. We know what the AI Act looks like to a very large extent, but a lot of the pieces of the AI Act, the details, and the devil, of course, always is there. A lot of them we don't know yet. So what I would suggest is adopting some form of scenario approach today, where you look at what are Number one, we'll go into the tactical details a little bit, but after identifying your role in the act, perhaps looking at, what are the different scenarios that could happen within those parameters, and then sort of making your plan based on that. Now, additionally, the regulatory landscape for AI will very, very likely evolve even after the AI Act's initial implementation. We already know that in the EU context, there's, for example, an AI liability directive being discussed. And additionally, of course, many of your organizations are also active internationally, and there's a lot of AI policy and regulatory efforts going on globally. So I very strongly suggest that you invest in monitoring the regulatory evolution so that you don't have to do this again every time in each market, and you can identify the similarities and the differences between different markets. Now then, my last strategic consideration, which might be a little vague as a headline, but nonetheless, I think it's extremely important for all organizations that do fall under the scope of the AI Act, which is investing in AI literacy. Now, what do I mean by that? I mean a few things. Number one, it means enhancing the compliance understanding. So what we are doing here today. It's important to equip relevant employees with the knowledge and understanding needed to basically comprehend the requirements of the AI Act, and that everybody knows what their role in compliance is. Additionally, it's very important to ensure that once the clock starts, once that 1 year or 2 year period, once we're across that period, that people inside of your organization have received role-specific, training, that they are really aware from day one of what is expected of them. It might be in very different things depending on your organization, but at least it will be your legal teams, your compliance teams, privacy, HR, so on. And of course, also if you are developing AI systems internally, the technical teams in charge of those development efforts. Additionally, I also think it's very important when we talk about compliance, very often people see that as sort of a purely legal exercise. But as I alluded to in my earlier point, it really is not just a black and white, a binary effort. And therefore, I think one of the key reasons why it's important to invest in AI literacy is to promote a culture of accountability. An organization is sort of only as strong as its weakest link. And by building a culture of accountability and understanding compliance, and where all employees understand their part, it leads to just more proactive identification and resolution of potential challenges. Now, moving over to some more tactical tips, and I'll be a little bit quicker, and I don't have separate slides for all of these points. Some of them might be very self-evident, but I think the first point, Pat also alluded to this, and I'm not going to add or repeat what he said, but it's really important to understand your role inside of this new framework. Are you using AI? Are you procuring AI? Are you doing a little bit of both? Are you, read through some of the first articles that talk about the different players inside of this system. Are you a developer? Are you a deployer? So on. Inventory all your AI systems. That's absolutely crucial. So you can even start to comprehend which rules apply to you. Then understanding your position in the value chain. That's kind of tied into what I mentioned. To assess and categorize in scope AI systems so that you can identify which risk classification they fall under, and identify the relevant applicable compliance requirements. And then eventually, once you've done that, it's extremely important to also engage with your vendors, your partners, your providers of different AI systems to ensure who has what due diligence requirements in that process and who is responsible for what information. And it's important to remember that just because the sort of requirements might not fall on you, you might still have companies, partners in your value chains, in your supply chains that you might need for information reasons. Point number 3, consider and identify indirect risks. This goes a little bit to the point that Pat also mentioned about the connection to, for example, the GDPR. So I think it's extremely important to not just map out the AI Act as a separate thing, but map it out as part of your full compliance environment, especially the GDPR. But there might also be industry-specific regulations in your industry that already regulates AI in one way or another. And frankly speaking, there is some risk of sort of overlapping regulations, but also contradicting regulations. So identifying those and making a conscious decision about the risk you are willing to take is really, really key here. It's all about being intentional so that you know what you are doing and where you are. And then it's much easier to deal with even potential problems down the line. Then, of course, engaging internal stakeholders, setting up processes, that goes hand in hand with the AI literacy point, but it's all about making sure everybody understands their responsibilities to make sure you are compliant. And there's a significant amount of reporting, especially if you have high-risk systems or you are a model developer, such as our company, Silo AI. And at that point, it might actually take some work to set up these reporting requirements and internal information gathering processes to be able to do reporting. So I do recommend to do that fairly certain. And then, of course, the final step, to the extent that is possible, verify that you are compliant. Engage in conversations with the authorities, both on a European and on a national level. Talk to stakeholders in your networks, engage with industry groups, industry associations, to talk to both what competitors and other companies are doing to ensure that you are at least maintaining the level of sort of, that you're comfortable with the level of risk you are taking. That is really all I have. I want to thank you very much for your attention, and I'll also be around for one of the panels, so I look forward to continuing this conversation. Thank you very much.
Now it's time for the panel, and I'm very curious about the participants. Who are they?
Thank you, Tilde, and thank you both, Patrik and Per, for these interesting talks. We have panelists now representing different perspective towards the AI Act. We have the commercial side, we have the agency viewpoint, we have the advisory role, and a more in-depth implementation side. So we are lucky in the sense that both the speakers will be joining us for the panel, and in addition to that, we will also be joined by Sara Rosa Agerborg, a lawyer and advisor from PwC, the consultant firm, with a focus on giving clients the support they so intensely need in the jungle of new and complex legal landscape surrounding AI, as well as Damien Niemeyer from Applied AI, an expert on AI regulation with a focus on making innovation happen, and not necessarily in spite of the regulation but burden, but rather utilizing the built-in mechanism of the regulation. Welcome to the panel. We will start up with a short warm-up round, getting to know you a little bit better. We'll start by shooting some questions to you respectively. And Per, you have been involved with the work with the AI Act from the public side for quite some time. And I know it's been an interest not only for yourself, but also for IMI, the agency you come from. We are currently awaiting the appointment of which agency will have the main responsibility for the AI Act nationally, and IMI is a frontrunner for this. Why would IMI be a good candidate for handle such a responsibility?
Thank you so much for the question. I mentioned a little bit some of the arguments, or two of the arguments. And first of all, I do think that GDPR, I know, is a complex regulation, and I believe that a lot of people will also think that the AI Act is complex. So there is already a lot of authorities that you need to speak to, so to speak. And I think it would actually facilitate if there would be like one authority to go to, one go-to authority more or less, because what otherwise could happen, as I've heard other people saying, is that, okay, you go to the AI authority, for instance, and they say it's okay, but then you don't know unless IMI or another data protection authority has said the very same thing. So I think that would be more efficient if it was handled under one roof. But also when it comes to the whole notion, because a lot of the notion used in the AI Act also refers directly on how it's defined in the GDPR. Profiling is only one example for that. And I think also that if you have one authority who's actually interpreting the very same notion, I think that would be more foreseeable for the organizations out there.
Great answer, Per. Thank you. And as you said, it would most likely be a very good approach to have a one-stop shop for the questions, somewhere to direct the attention and to culture interactions with. Damien, you come from what we call our sister organization in Germany, Applied AI. And you are working on accelerating the use of trustworthy AI in industry applications. What is your take on the outlook of this if it wouldn't be that we were introducing the AI Act now in Europe?
I mean, it's really important to have the geopolitical realities in mind. So like 2 years ago, it was like AI was developed locally and deployed globally. So there was not any kind of market entry restrictions for AI system. Like with ChatGPT, it got deployed in United States, and a month later, there had been 100 million people using ChatGPT. But at the current state, like it's not just Europe regulating AI. It's happening in Brazil, in the United States, in Japan, in China, and the Arabian states. So if European Union would not regulate AI on the European Brussels effect, there would be a risk of 27 member states having each their own distinction in national AI regulation. So there would be much more fragmentation. So the European way of saying we want this digital single market, and also AI is part of this, is totally sensible and with geopolitical realities like the best approach and even good for innovation. I mean, the innovation hammering stuff is other stuff like government's implementation, like weasel words, like standards are not developed already, but the idea of regulating AI on a European level is good.
Wonderful to hear. Now you paint a picture of nightmares when it would have been a plethora of different legislation that we would have needed to navigate in different countries within the EU, especially over the inner markets. And you can see a little bit about that of that happening with the privacy laws in the US, right? So we can see how it's not working in that sense if you try to not regulate it. So yeah, thank you for your answer, Damien. It's a good insights. So Sara Rosa, you're as a consultant giving guidance on complex topics such as how to handle the regulatory landscape around AI. I imagine you face plenty of challenges, right? And establishing new fields of expertise often leads to new interdisciplinary teams being established. Which competencies and roles do you find necessary to involve in the governance process going forward?
I would like to say all of the roles and everyone, but just to minimize the people that need to be in like an AI project, if you're a developer or procurement or something like that, I'd say it's important to have the management and the board engaged, as it's a risk-based framework. So they need to be able to know what they're accountable for. But then I also think that of course, you need lawyers, and you need lawyers from different perspectives, from data protection, from intellectual property rights. You need the AI lawyers, but you also need the cybersecurity experts, the developer, the AI experts, the people actually coding the products and the AI systems. And I also think that it's important to involve the end users, depending on where you're providing your AI system to or who's supposed to use it. If it's my colleagues or we use it in our everyday work as lawyers, then we need to have my colleagues testing the AI system to understand its risks, its benefits, its efficiency, and to be able to actually upskill us in a proper manner to be able to utilize these tools.
Very interesting.
Yeah.
And as you said, this will involve almost all different aspects of a company or an organization which utilizes AI in their offer. Yeah, so this will be, of course, a a very interesting time going forward, both in how to find a competency and how to make him work good in collaboration, of course. So moving on to you, Patrick, you come to us with a little bit of different experience heading up the business route, right? So it's always a risk when lawyers get together and the business perspective can sort of be missed in that regards, right? It's quite common that we apply a little bit of a overzealous and overcaution approach. You mentioned in your speech the similarities with GDPR. Do you see the possibility to use external resources in the same way as many have done with the GDPR work? Can this be outsourced?
So I want to start by saying that I don't fully agree with your starting point. I have a lot of lawyer friends and I do respect their work a lot. And I come from the world of politics where I used to work. So I do know that sometimes when politicians actually draw up laws, the lawyers have to clean them up afterwards. So I do have some sympathy. No, but on a more serious note, I mean, I think approaching this compliance, kind of what I tried to say in my talk is, look, it has to start with the organization itself, understanding its role in the system. And that's the point where you start deciding, well, will I need external help or won't I? There is no one size fits all solution for everyone. I think for a lot of companies, it might be good to hire outside experts to support the work you are doing, but you do really need to be in control yourself. So I would personally not recommend that anyone fully outsources compliance because I'm looking at this from an AI labs perspective, and the crucial thing to realize about AI is that it's not a thing that's over here. AI is a thing that is inside of products, it's inside of services, it's inside of processes. So it really needs to be at the core of your company, and your company needs to understand the technology it uses. So if you outsource that fully, basically you are outsourcing part of your product work, part of your strategy, and I mean, no company is ready to do that. So I think it starts with your own starting point, what you feel comfortable with. There's no one size solution, but I would not fully outsource compliance.
Sounds like a wise approach to at least know the important and crucial points of your business and keep them in-house. And in that regard, you can also, of course, as you said, include experts when bringing that to a higher level. So on that topic, Patrick, let's check in with Sarah Rosa, because it's intermingled a little bit with what you do, right? So there's often talk about these kind of laws being a cost-driven action, but lately it has been discussed, at least from the GDPR perspective, that you could also see revenue streams from the aspect of the compliance work. So, Rosa, is there a way to package the consultant role to help create value in regards to AI Act, do you think? Competitive advantages or such that could be created?
Yeah, it's a big question. I think that as a lawyer, I'm very pro technology and I like to try new things. And I can see that AI will help me with perhaps legal research or contract analysis in the due diligence process, in mergers and transactions, perhaps also document automation. And in the most easiest manner, just in process automation, it can help me draft an email if I don't have the time to formulate myself in a very polite manner or make my everyday work more efficient. But I think it's important to still understand that even though you're using AI, it should be human-led and tech-powered and to be used as a tool. I think we can provide more high quality and efficient work as lawyers, but we still need the human review, the human-focused mindset that we need to quality assure our work, as well as to know that the value we contribute with to our clients might be made more quicker and efficient, but it's also still a value.
Very interesting. And as you say, I think you could definitely find applications within the consultant work where some are repetitive tasks and some are more high dimension tasks with strategic approaches.
Yes.
Patrick, what do you think about using compliance as a competitive advantage in this regards?
I mean, I think it's a sort of a double-edged sword, right? To not to sound too much like a politician again, but it's sort of, you know, it's you can look at it from two ways, right? Of course, I think any company wants to ensure that they are. I mean, it's a hygiene question of course being legally compliant. But I mean, as we've talked about, it's the first time AI is being regulated. It's not a black and white thing. It's hard to say when are you compliant and when are you not. So I do think the important part is to start with sort of, am I following not just the letter of the law, but the sort of spirit of the law? Am I really making a good faith effort? And I do think the reasoning and the methods through which you arrive there are very similar to a lot of efforts companies want to make to sort of create competitive edge for themselves. So look, you know, at the core of the AI Act is things like transparency, respecting human rights, things like this that I do, you know, expect most well-functioning and sort of good companies to want to live up to anyway. So I think it's really about how you approach it, but saying sort of that regulation in and of itself can create competitive edge is perhaps a little bit over too optimistic as well. And I do think it's important to also be very mindful that while I do agree with Damien's earlier point that it's important, it's better to have one European framework than 27 scattered different frameworks, we should also be very mindful about the fact that we have regulated technology a lot in Europe over the last at least 5 years. And the holistic impact of that on the technology sector is kind of still to be decided. We don't really know that yet. We always assess the impact of legislation one piece of law at a time. We never assess it holistically. And personally, I am getting a little worried about our eagerness to regulate technology in Europe and not necessarily taking enough into account the innovation aspect, which unfortunately we are losing a little bit on a global competitive scale.
I think you are onto something there, Patrick. There's a risk in regards to this as well, as you say. So moving down a little bit further down the line on the implementation scale, Damien, I know you are looking into the runway of AI Act application applicability, and as an example, sandboxes that can be used for testing out new applications. A topic I know also is dear to you, Per. Sandboxes being the regulator's way to create a safe space to try out new application without causing harm to a third party, right? Damien, how can we handle the threshold that many, I think, especially smaller companies sees with regulatory sandboxes?
I mean, the policy instrument or regulatory instrument of a regulatory sandbox is a quite new approach to bring like innovation and regulation in a dynamic interaction with each other. And those regulatory sandboxes which are already being done, so the existing ones are mostly like sector specific, fintech, privacy data, transportation, blockchain. And now we have the AI Act aiming to like a general purpose technology of AI, which you can spread to all sectors. So I guess it's a big promise the European Union is bringing in the AI Act with the regulatory sandbox and bringing innovation into it. So there's a hell of question marks about like the design, like overlapping competence. You need like a legal basis for competent authority to give legal leeway. So to refer from the normal legal you have to follow. So I guess it's a big promise. I hope it will do. Like in the best case scenario, it sounds awesome. But it's a big claim, and I guess there will be a lot of stuff to be done. And there's a good reason that there are so many weasel words in the AI Act addressing regulatory sandbox. So there's not anything clear. So it can, but it's a hell of effort to be done by the European Union.
Thank you for that, Damien. And I think that's the cue for Per. How are EMI working with sandboxes today, and what do you think will be the usage in regards to AI Act?
So we have conducted a regulatory sandbox now for I think 1.5 years almost, and that is something else. That is another form of regulatory sandbox in relation to the regulatory sandbox regulated by the AI Act. So it's not exactly the same thing. However, what is identical is the work method, that we actually work with real cases, with real participants, with real questions. Mainly within the gray area. And we know a lot of questions are within that field when it comes to the GDPR, and it's about solving and understanding the technology, because it's most of the time it's using and deploying a new type of a technology or an existing technology new ways, and how is that related to the GDPR? How can we interpret that in order to solve as many problems or questions as possible? And so this is actually, we have, as you mentioned earlier today, Billy, you actually participated in our very first one on federated machine learning. And we as an authority, we learned so much, and we're super grateful for all that knowledge, because it is really relevant that we as an authority also understand and can keep pace with the technology out there, with the development, because otherwise we won't be able to apply the rules as they should in reality. So it's this is a really fun and super crucial way for us to do that. We do many other things as well, but this is one crucial puzzle actually in that context. Another thing that we also do, and that is not only IMI or the Swedish Data Protection Authority, but we also do that together with Bolagsverket, Arbetsförmedlingen, and ESAM, and the Swedish Tax Agency as well, is that we have simulated a regulatory sandbox according to the AI Act. So that we have actually selected a project from Arbetsförmedlingen and actually conducted that project as if the AI Act would be applicable today. And that is one way for us to prepare ourselves to actually handle projects within the regulatory sandbox for AI according to the AI Act.
Thank you, Per, for that insightful comment, and I can just send that appreciation back. We learned so much collaborating with you on the first project as well. It's something that we reference quite a lot and still work on sort of a 2.0 on that one. And we have been following your latest one as well, which was in LiDAR, I think.
Yeah,
which was
it's
very
true.
interesting. So I would like to advocate for the work you do there, giving guidance on unclear questions, because that is very appreciated work you do. So if you haven't noticed or haven't seen those reports that IMI put out on these kind of questions, I would highly recommend you to go into their website and check that out. So with that warm-up session, I hope you feel loose and gathered in continuing the discussion about AI Act. I will turn to Tilde, who's been curating the Q&A section for us, and see what you have been able to find.
Yes, we've got some very interesting questions from all of the participants. And let's start with, here is a question. It doesn't say who will answer, so maybe I will just read it up, and someone of you maybe want to start. So, is there anything in the AI Act where the requirements scale based on the size of the company? If not, how has the EU reasoned that the AI Act should not stifle innovation in the field, assuming that innovation often comes from small players? OpenAI wasn't the largest not so many years ago.
Yes, I see Patrick is raising your hand.
Yeah, shoot.
Go for
So
it.
I think since the reference to OpenAI, I think probably what the person is talking about are the specific so-called GPAI provisions. So this was, of course, what kind of entered into the AI Act during in the middle of the process. So general purpose AI models, as they are now called, I think some parts of at some stage they were called foundation models, but basically the idea is that there's sort of two sets of rules inside of the AI Act, right? So there's the risk-based categorization for AI systems, and then there's a two-tiered system, a systemic or non-systemic risk tier when it comes to these general purpose models. So the best example or most well-known example is, of course, generative AI models, be it, something like a ChatGPT or a Midjourney or one of these tools that I'm sure a lot of people have used. In those rules, there are some exceptions related to open source, but not exemptions related to the size of the company. And frankly speaking, representing a company that also develops models with limited resources in that stage, and much more limited resources than some of our competitors, especially from the other side of the pond, we are a little bit worried about this process, because over the next year, there's going to be a process to develop codes of practice that basically, until there exist international technical standards, the codes of practice will apply. And I mean, just as an example, that group will meet at least once a week. Now, at our company, I am our entire public policy department. We have one lawyer working for our company. If you compare that to Google or OpenAI or Meta, they have a few more. So the resources, it's sort of a meta point when it comes to compliance. And when it comes to this, it's not that we don't want to comply with the rules. It's just that it's extremely difficult for us to have an influence in the rule making, and then ultimately also in compliance when it comes to that. So I think the question is a very valid one. And I do hope that in the future, and during these processes, now that we come up with the sort of more detailed rules, but also in the future when policymakers come up with new rules for different sectors, that they do take into account also the resources on compliance. Because frankly speaking, it has nothing to do with our intent. It has nothing to do with what we want to do, but you create a de facto competitive edge for bigger companies with the more complicated the rules are.
Thank you. Very good answer.
I see Sara, so you want to weigh in on this as well?
Yeah, just to add, I totally agree, but also that the AI Act or the European Commission has tried to simplify ways of compliance for small and medium enterprises, including startups. Then that's supposed to be that they can have simplified technical documentation and simplified access to regulatory sandboxes and awareness raising, training and activities dedicated to just small and medium enterprises and startups then. So I think that we might not have seen evidence on that yet, but it's also this reasoning behind the act that it's supposed to foster innovation as well. So I think that hopefully soon we will start seeing more and more on how the European Union will actually utilize this and make sure that these companies that foster innovation also get a chance to be compliant.
Very good. I think, yeah, Per, I see your hand is raised as well.
Yeah, since I talked about the regulatory sandbox, it seems like I cannot drop it. That's another way where actually small and medium-sized companies will have priority access to participate in the regulatory sandbox for AI, and it should also be for free. So that's also one way of incentivizing the small and medium-sized segment.
I think that's a very good initiative, because as Patrick mentioned, it's a high cost for compliance for especially small companies in regards to the total turnover or revenue. And I think you mentioned before, Per, also that as you see it, there can be a lot of reuse of the privacy work done through the GDPR compliance. And I think that's something that we hope for as well, right? That the legislator keeps on keeping a sort of a red thread going through it. Yes.
Yes, next question. Since AI will be used across different functions with a company, which department or function within an organization is the most suitable to be responsible to the overseas compliance of AI Act? Should it be the GDPR department, compliance and ethics, or IT governance?
We want to weigh in on this one. Patrick, we have a successful approach now, so you go first.
I'm sorry, I don't want to sort of take too much space, but I felt like that was perhaps a little bit directed at what I was talking about earlier. I think, again, the boring answer is like there is no one size fits all solution to this. It really matters where your company has these resources. Some companies, basically embed compliance resources into technical teams. So you might have, in bigger companies, I used to work at Tesla. We had a lot of basically engineering compliance people that worked inside technical engineering departments, but had sort of a strong and compliance role in an industry like the automotive industry that obviously has 70, maybe years of compliance experience. However, then if you work in industries with perhaps some shorter, experiences from this, it might look very different. I would suggest that the key thing here is to don't really think about this in terms of departments, but really set up cross-functional teams to work on these things. I think that is the absolute key part. And that cannot be just sort of compliance experts. You need the technical experts. If you're in any way developing technical systems, you need the AI engineers, the AI scientists, whatever their titles, software developers, what they might be, but they really need to be involved, because a lot of the data you'll need for the reporting, they will have to know about long before you actually need that data. So it goes to how they design sort of the architecture of the actual system. So I would really strongly suggest, especially when you're starting out, to have as cross-functional as possible a team. And then perhaps when you map out and you realize where you are in the system, perhaps then some departments can jump out of the group and so on. But yeah, really start cross-functionally.
Very good answer. I don't know if I saw you, Per, raising your hand a little bit earlier.
Yeah, but I completely agree with Patrick. I think the most crucial thing is that you have a cross-functional team consisting of both lawyers and tech people, and because I think it's super important that they start talking to each other, and not only talking, also understanding each other, because now I believe a lot of the lawyers are a little bit afraid of tech and vice versa, actually. So I think it's super important that we really start to understand, have a basic knowledge of technology as well. I think that is important for lawyers. Yeah.
Very good.
Yes, let's see. AI development moves quickly. How do you safeguard that this regulation doesn't stifle development in this important area? I think it was like answering a little bit. Something. Yeah, you want to add something to this question?
Yeah.
Yeah, I mean, I can just shortly highlight that the idea of the AI Act is to be agile to technical developments, in that sense that they just use this kind of abstract wording. Your AI system has to be transparent. It needs to be cybersecurity robust. So like, what is it really? This will be totally done by standardization. So if in 3 years' time, there will be new technical implications to AI systems, like just the standards can be adopted to this change. So you do not need the legal process itself. And then the European Union can also do like, it's called like implementing delegated acts. So the AI is like the primary law. And here and there, some additions can be done by like secondary law. So it can be adopted quite easy. And also referring to the regulatory sandboxes, the idea of those is not just bringing legal clarity for the innovators to the legal framework, but also regulatory learning on the legislator side. So like the regulator is capable of addressing any kind of technical advancements quite early, because they get knowledge of this stuff, what is happening in those sandboxes. So this is the idea. And the traditional laws, they mostly have taken part in judges. So this was mostly how laws get adopted. Judges saying you're not legally compliant, or the law is not fit for constitution, whatever reason. So this is a new way of bringing flexibility and a much more fasting development global economy. So this is the aim, and I guess it's reasonable, but a lot of stuff have to be developed to really each part fitting into each other.
Good answer. I think as you said, there will be a legal development and R&D going on in parallel here from the sort of the cross section between public and private here. Patrick, I see your hand is raised as well.
Yeah, just a short point to add on. I completely agree with what Damien said, but I think one thing I would sort of implore policymakers is also to, we are sometimes in Europe, we look inward, but we also need to look outward, because, taking into account the sort of a lot of the risks that we do see, and that are absolutely valid risks and considerations to take into account, just regulating them in Europe will not sort of stop anyone else from doing these things. And I mean, that of course is always going to be an issue. I understand that. So I'm not saying that's a reason not to regulate. But what I am saying, when we come into these technical standards and the technical details, I think it's really important that we also look what other jurisdictions are doing and maybe have a little bit of humility, not just say that, you know, we in Europe want to export our regulations. Maybe we can also look at what other countries are doing. And I'll just use one example from the AI Act. So on the GPAI provisions, the first limit for if your model is systemic risk or not, it's flops. So floating point operations, in other words, the compute used to train the model. In Europe, the limit now is 10 to the power of 25. 1 month earlier, they said the rules in the US with the executive order from the Biden administration, and that's 10 to the power of 26. Now that means, and I heard this directly from someone who sat in the trialogue negotiations, that they said that, you know, the European rule limit is only slightly lower. Well, if you understand mathematics, it's actually 10 times lower. And so we have these sometimes unintended, you know, situations where obviously these bigger models will end up being developed in the US still. There's no reason they won't. It will just be more expensive to do so in Europe. So it will not mitigate any risks, but it will just be more expensive. So I do hope that we also take a little bit of sort of regulatory humility into the discussion and look at what other jurisdictions are doing, and to the extent possible, coordinate with other jurisdictions.
Good answer. Good answer. Tilde, what else do we find in the Q&A section?
We have a question for Per. What points in GDPR AI Act has the most people misinterpreted?
Wow, that's a good question. If I put it like this, I think, according to my experience at least, I think it's a lot when it comes to developing AI, finding the right legal basis, I think is like people find tricky, which I do understand, especially when it comes to public sector, because in order to find a legal basis, there are 6 different types of legal basis, and when it comes to public sector, they can only use some of these 6, and then also the legal basis need to be specified in a regulation. And of course, a lot of these regulations are not updated. They were not created having the AI thinking in mind when they were actually when they were created or drafted. And of course, I do understand that that can be a very tricky sometimes to actually find a suitable legal basis, because the law is not always updated, or in this case, it's not updated.
Very good, Per. I think also that one question that we have heard in many situations is that the data people have collected in different aspects, when they are going forward using it in, for example, training of new models, that of course mostly fall out of the scope of the original collection. So I think that trying to find a way to mitigate that is something that people work quite intensely on, and trying to sort of color in the gray zone a little bit.
Exactly.
Yeah.
And that's one way, actually, according to, if you participate in the regulatory sandbox for the AI, according to the AI Act, then under certain circumstances, you will be able to use that data that you already collected for one purpose to also in order to create another AI model. But that is also under certain circumstances within the regulatory sandbox.
I think that's something that people or many companies are interested in looking into more. So is that something that you could find readily on your website if you want to learn more about that?
Not now, but definitely in the future, yes.
Yeah. Wonderful.
Yes. And we have one more question for Sara Rosa. What common legal challenges do companies encounter when implementing AI solutions in their operations?
Oh, I think the most common legal challenge is the overlapping laws and regulations. We have the GDPR, which we talked about here, it's been mentioned, but also intellectual property law. It's like a global area or legal landscape that's very hard to interpret, and it's very, very, very much to know about it, and that makes AI and copyright very hard to investigate. And it's also, you usually have a lot of open source licenses, you need to read those as well. And we have product compliance, you need to know which sector you are in. And I think that's like one of the most complicated things. So if I would start with something when implementing legal solutions in forms of AI, I would start with first trying to figure out, and it's been mentioned here as well, what sector am I in and what laws apply to my operations in my company. And then I do an AI inventory or portfolio management to start be able to map where to start and where's the highest risk set.
Thank you. We have another question. I understand that GDPR does not apply to private individuals. Am I right? But what about the AI Act? For example, people who contribute to open source projects that build AI models or systems, what applies to you as a private individual then?
Sorry, Rosa.
So the AI Act does not regulate personal use of AI. And so just making sure it's not in a professional capacity or a commercial, then it's not applicable to you as an individual.
Thank you.
And you, Damien, I see you raised your hand as well.
Yeah, just to add, like, but you as a private person can be affected person in the AI Act. So you have like legal reason to address an AI system being affecting you. So it's more like you have as a private person rights from the AI system,
Yes.
not like the other way around. So it's like also a little bit kind of consumer protection already in the AI Act, which is quite not the standard for product safety regulation.
It seems reasonable. It has been referred to as a product safety law in some regards. So it takes that approach in some instances, right? I don't know if we want to clarify on the other or the first question as well. I don't know if you, Per, want to expand on the GDPR's application for applicability for private persons.
Yeah, so the GDPR is not applicable to personal use, basically, but still a private person could very well be, the GDPR could still apply to private person depending on what you do. For instance, if you're public anything on the internet that anyone could see, for instance, then you cannot go say that this is for personal use. So it's also during under certain circumstances where you can actually use this exemption that you as a private individual are exempted from the application of the GDPR, but not always. It depends. The typical
so there's quite a
lawyer
lot of similarities
answer.
in that regards than between the AI Act and the GDPR is that it's not necessarily the legal subject that is concerning the applicability, but rather the usage and such.
Exactly. That's correct.
Very good answer. Thank you.
See, one question for Damien. How can you help companies develop a robust AI strategy that takes into account legislation and regulation across different industries?
I mean, it's really complex, but I guess in the first hand, it's really important to have a clear understanding, like the AI system I'm developing or deploying, like with what kind of risk classification it is. So if it's like the risk class of prohibition, you cannot do it anyway. Like high risk, you have a lot of legal, technical, organization requirements. Limited risk, there's some, and if it's low risk, there's nothing. So it's even like AI Act is not regulating you. And I would say the most complexity of compliance with other sectors will be in those of high risk AI systems. But anyway, like it's not this kind of risk-based regulation is not new. So you cannot simply open a bank or sell airplanes or give equipment to hospitals. So if a high-risk AI system is affecting you, the sector you're working in is already highly regulated. So you should know your sector regulation. So the AI Act is just giving another layer of regulation and requirements. But the sector stuff is really complex, and a lot of those overlapping stuff is unknown. to the other horizontal European regulation stuff and to the sector parts of regulation. So I guess the most feasible stuff is, in best case, you already know the sector you're working in. And if not, you should contact your authority, which is supervising you, and just make a documentation that you have the best approach, like Patrick said, in being compliant. I mean, if there's gray area and no one really knows how to do it, how should you know it? So you just have to document that you try to figure it out. And the best part, something can demand from a company to do this. And it will just evolve over the next 6 months, 1 year, 2 years, 3 years. So just monitoring it.
Very good, Damien. I think you're mentioning a very interesting topic there with the intersection between domain regulation and these sort of more general regulations that is coming out from the EU with the digital in the market and whatnot, and especially then GDPR and AI, for example.
To add, I can just post it here in the chat. We just published the compliance journey. So you have like a brief overview of all the phases of the AI Act itself. So there's not any kind of sector part in it. We're thinking about doing it, but there's a lot of stuff you can do at the moment. So, but I would just keep it in so you have like an overview of the compliant part of the AI Act.
Thank you, Damien. Very, very, very good expansion on that. I don't know that this is more of a general question. We know that EDPB is an actor when it comes to the GDPR, providing us with a lot of different kind of opinions and explanations. Do you think that we will have the same in regards to the AI Act, and who would that player be if that's the case?
Well, it will be first have AI office, which is a part of the EU Commission, and then you will also have the AI board, where there will be representatives from each country. And one of the missions for, I think if it's the AI board or the AI office, but they are, one of the tasks are also providing guidance, and similar to what EDPB is doing now. So it will be in a similar way, so that it can be used throughout the entire Europe, or EU at least.
Very good, very good. We'll hope that they will have they will be efficient in providing us with these kind of opinions, because I know that has been an appreciated part when it comes to trying to implement GDPR in many different cases. So as you mentioned also, Damien, before, that we will find this kind of secondary legislation being developed, and I think that this would be one way forward. As well as also the standards, of course, that will be developed in unison. Tilde, what do we have for them?
We have a question for all of you, and the question is, could we get some real-world examples of AI usage that will now become illegal?
Patrick, go for it.
Well, I think the most obvious example that's also sort of been discussed a lot if you've read news articles and followed media discussions around this is a sort of social scoring type of system that you see in China that obviously has raised a lot of interest and for obvious reason a lot of consternation and this is completely me speaking in a personal capacity, but I'm at least very pleased as a European that indeed will get banned, and I do think like the political debate around it wasn't very controversial, but I do think one important point that maybe and this is of course a subjective analysis of the discussion, but one point that has not necessarily been as visible is that there is a fairly broad exemption actually for military and national security applications in terms of the different in the prohibitions. I mean, so at least when it comes to defense industry and when it comes to that sector, and I'll leave it up to all the listeners to make their own judgment call whether that's good, bad, or something in between. But there is sort of a lot more leeway in that context. But yeah, I think the social scoring system basically, think about like a Terminator system that judges everything you do and gives you a point for it, and then you get ranked compared to other citizens. That is indeed prohibited 6 months from the AI Act entering into force, and personally, I'm very happy about that.
That's a good choice of favorite illegal applications, Patrick. Damien, I see you are eager to go into the discussion as
just to
well.
add to Patrick, there's like a Chinese movie, like from Chinese dissidents. It's called Total Trust, and this is like basic all the, I would say, like Chinese authoritarian AI cases of technology, like are part of this movie. So it's Total Trust. I can also put it in comments, and when you've seen it, there's much more reason and acceptance for the prohibition of AI systems. So, yeah.
It's always tricky when movies and books are more inspiration to these kind of authoritarian states than sort of dissuasions. So what favorite illegal applications do you have? What would worry you the most if they came to be?
I think I would not be a fan of emotion recognition nor predictive policing. I think that's bad areas to allow AI in. So that's a dystopia for me.
Yeah, Minority Report didn't seem like the perfect utopian world, I would say, right?
Exactly.
What inspired you to go to work every day? Because this is something that you are sort of counteracting, I would say. So what drives you there?
Yeah, but of course, I will agree with Patrick. The social scoring prohibition, I am fond of, to be quite honest. But another thing also, which is the real-time remote biometric identification systems used by law enforcement authorities in public places. That is not an absolute prohibition. So there will be actually exemption that can be made from that prohibition. But of course, the whole purpose of that is hindering mass surveillance made by governments. So of course, I think that is crucial, that it's regulated. But I do understand at the same time, all the gang violence that we do experience here in Sweden, I do also see that there is a need, but I think it's really good that it's regulated.
I think that's a very, very good mention as well. We have a important election coming up here locally in Europe, and in some time also a very interesting election in the US. I don't know how many of you remember Cambridge Analytica during the not last but second to last election. There's been a great discussion about how AI could have been used in the application of those kind of influences campaigns. What's your insights on those kind of aspects of AI? Patrick.
So maybe it's good to preface this with this is a completely sort of personal reflection, but I've lived in the US a couple of times, and I've lived in Brussels a couple of times, and I think I've even stood as a candidate in a couple of elections. And I think looking back at sort of my campaigning experience and following and working on different political campaigns, I would say, maybe 2 points. Number one, of course, I am sort of in, let's say, the midterm, a little bit worried or worried about sort of the proliferation of disinformation and misinformation that has been talked about a lot. That is absolutely a real concern, and AI can absolutely make that worse. But I would sort of, on the other hand, though, mention that, it's already a problem today, and it was already a problem before the proliferation of generative AI. And I do think that what Europe has tried to do and the US has failed to do in terms of regulating the platforms, I think that is sort of a key kind of point of where you actually can do something from the legal point of view about these issues, because I do think that we see more and more, at least from my opinion, more and more evidence of how these platforms, social media platforms, where people spend an increasing amount of time on, according to some studies, teenagers already in the US spend up to 7 to 8 hours on social media per day. So it's not really about a place you go anymore. It's actually where you live. It's where you spend your time. And just like we regulate a lot of other things on where you spend your time and the information you meet there, there's we're speaking, I mean, I'm in Finland, but we're speaking in both Finland and Sweden. There's a ton of laws about marketing, what rules you can have on, the types of ads you're allowed to place on buses and stuff. And if you think about how social media to a large extent today still is a complete Wild West, even in Europe after these rules. I do think we sort of have to identify the points where we can regulate this and look at it sort of from a product safety or a customer safety point of view and say, look, especially for young kids, who are in their formative years, this is where they spend a lot of their time, and this is where a lot of these harms can happen. And it's not just about sort of what is the thing happening in one election, but it's also the long-term harm that that can have on anything from mental health, where we see some disturbing trends, especially among young girls, as a result of social media influence. So I do think, misinformation and disinformation is a thing to take very seriously, as I know our authorities are doing it. Myself, I've worked at the Ministry of Defense in Finland, and I know that the defense forces and security people are very serious about the systemic effects of hybrid warfare and misinformation. But I also don't think that we should sort of just look at a new technology and say, look, that is the scary part. Like, this problem is already here today. And I think we should be very practical about how we solve that, and not just point our fingers at the new scary thing and paint these scary future scenarios, which are frankly very speculative when there already is real harm happening today.
Good insights, Patrick. Anyone else who wants to weigh in on that topic of disinformation? I will continue. Yeah.
Yes, continue to the next question. We have a practical question. What measures should be implemented to ensure that the development and deployment of artificial intelligence are ethical, transparent, and beneficial to society while minimizing the risks and potential harms? So what kind of measures?
It almost sounded like the preamble to the AI Act. So I think to a large extent you could say that that is almost word for word what the AI Act is aimed at doing. That is sort of the stated objective. If you read press releases from the European Commission or Council or Parliament, then of course it remains to be seen what works and what doesn't work. And I think that's also something that we have to sort of get used to in a world of rapid technological advancement that will only get faster. These development cycles only get shorter. So there needs to be sort of regulatory nimbleness and agility in terms of what rules work and what rules don't work and how can we make them work. And I think this is extremely important that fora like these are arranged. I think it's super important that regulators have an active dialogue with stakeholders, be it companies, but also listen to civil society and citizens directly on the impacts, both by the technologies, but of course also the regulation, because putting the expectation that sort of one piece of law with like 300-400 pages is going to solve all problems is frankly speaking, in my opinion at least, completely unrealistic. So we have to be sort of nimble, and we have to be able to adjust as the world and the technology adjusts. While of course, personally, I work in a technology company. I'm a technology optimist at heart. I also do believe it's very important to see the opportunities and possibilities of technology. I mean, AI, we already see solving problems in anything from, healthcare to energy to education. See a lot of immense opportunities and relatively low-hanging fruits available out there right now, and super, super cool innovations happening that really solve important societal problems. So I do think, like most coins, it has two sides.
Very good answer, Patrick. Building on that a little bit, Per, there's a lot of talk about the transparency part of AI Act. Do you think that because the transparency sort of put a requirement of showcasing what data you have been using, for example, training models, can there be a conflict between GDPR and AI Act when it comes to how transparent you can be depending on what kind of data you have been training on?
Yeah, absolutely. Because the opacity or the explainable AI, that could be challenging sometimes to actually live up to, definitely. But we also see a lot of research going on for how to actually make AI more explainable. And I also think that's going to be a requirement in the future, because I do think that a lot of individuals are going to require and request that you actually know what happens to your data that an organization is processing. But it is challenging. I do understand that it could be sometimes.
It's a tricky question.
Can I maybe just add one point about that? I
Of
think
course.
looking at this from a model developer's perspective, where I'm working hard with our AI scientists and engineers right now to already try to be very sort of we want to live up to the AI Act, not just as I said the letter, but also the spirit of the law as quickly as possible. And I think one insight I've gotten over the last few weeks trying to do sort of the very nitty-gritty work of this is, it really is a lot about process design from a company point of view. So you really need, a model development process is actually a fairly long process. You start with collecting data, which can take a very, very long time. It's hard to find good quality data. It's not just, like sometimes it's said maybe a little bit jokingly that, you just download the internet and throw it at a lot of compute, and then voila, you have an AI model. It's a lot of work that goes into finding the data, curating it, making sure it really fills up, lives up to the promise you want it to. So there's a lot of work that goes into that, and these processes are relatively long. And I mean, frankly speaking, also very expensive. So from a company's point of view, it's very important, to start looking at, I mean, even if we have a year to comply with these provisions, we need to look at it now, because we're already planning model releases that will happen over the next year and possibly even longer than that. So when we design our internal model in a data acquisition and data curation processes and strategies, now already we're starting to take into account sort of these AI Act principles, because we want to make sure that, down the line, as I said, not just filling up the letter of the law, but the spirit of the law. So I would really recommend all companies working on model development specifically to actually really start this work sort of very, very soon, because it will have implications that you can sort of, it's not just about reporting. Because, for example, saying what data you've used in your model, while it might sound like a very easy question to answer, I can actually promise you that it's a very, very tricky thing, because you buy some data sets, maybe you get some from some free repositories somewhere, you might download some from a national library. So it's very disparate sources, and they have they give you different levels of information of what that data set contains, and the amount of content in that data is so immense. Those data sets are so huge. So it's not just like you can sort of scroll through them and go, oh, look, see what's here. When we trained our Poro model in just the Finnish and English languages, it used something to the extent of 3 trillion words. So 3,000 billion words. So scrolling through that will take you a while.
That's a word count you didn't want for your essay when you were in school, right? It's a lot of data. And building a little bit on what you said, Patrick, and sorry, Rosa, you mentioned copyright law or intellectual property laws. I don't know how many of you in the event here have heard about Books 3. That was a controversial data set that was taken down quite recently, containing a lot of pirated copyrighted material. How would you say, Rosa, that companies should go about assessing that they don't do unplanned, at least, copyright infringement when going forward with collecting data?
I'd say that what Patrick just mentioned, to get started with the essence of the AI Act, keeping it in mind when you're collecting data, that the AI Act touches upon copyright and says we need to follow copyright laws. So then we can't use all data that's out there, because if it's copyrighted, if it's protected and someone else owns it, then maybe we can't have it in our data sets. And that's the documentation and the very many words we just talked about, that we have to document this so we know which data sets we have, which licenses we have, if it's open source data, if it's proprietary data, if it's our own data. And that's a crucial thing to keep track on, to know that when you launch your models, and also if you sell your models, if you use them internally, or whatever you do with your models, you want to know that they're secure, legal, and that they won't affect your company or any other company in a bad way. So you have to risk manage this, and copyrights would be a huge part for companies to get a grip on.
Very good insights on that. Damon, I know that you have been working a lot with creating a sort of a blueprint or a roadmap for implementing the AI Act. Could you expand a little bit on now that companies sort of getting the notion to look into AI Act and have gotten all these good insights on how to reason around it, what's the starting point? We have talked about doing an inventory about application, but what can they more do? What can they do more?
Yeah, like at the beginning, like it's thinking about if the AI Act is applicable to EU, what you're doing to a system. So it's mostly like, is it really an AI system? So it's the definition of AI system. Then it's the territorial scope. So for example, even if you're in the United States and you bring an AI system or the output of the AI system Europe, you are nevertheless regulated by the AI Act. And the last phrase was also the timeline. So the time when you have to follow. And like Patrick mentioned in his documentation, it's like the transition period, 6 months, then you have to get rid out of the prohibited AI system, and 12 months for general purpose models, and also 24 months for some high risk AI systems. And there's one specific article which says if it's like a legacy AI system, so if you deploy this AI system in those 24 months of transition period, you're not obliged to follow any of the technical and organizational requirements of the AI Act. So you have some kind of legal leeway in the next 2 years to just bring an AI system on the market and play a little bit around, get experience and get some knowledge. And just if you do after the applicability 24 months some changes to the model, then you have to again rethink if the AI is applicable. And besides this, the next step is what risk classification I'm in. So this is the most important viewpoint, like if I'm applicable, and if yes, what is the risk classification? And then like the real compliance work is starting. But it's important to make this question at the beginning, because you can do too much or you can do stuff you're not obliged to do. So the next 2 years, there's a lot of free way of testing without being regulated.
Thank you for that insight. I think it's very interesting that you mentioned that there is this kind of leeway you mentioned that will create a sort of a space to also try out legacy applications on the market on those 24 months. I don't think that many people know of that, so I think that that's something worth looking into more if you do have applications already developed at this time. I also know that you have done a great work and published compliance journey addressing many of these questions, right? Which can be found at your website at Applied AI. I think also that we will share the resources when we post the event on My AI. So that's something that's worth looking into. So with that, we thank you all for your interesting insights, and we're slowly reaching the end of this event, and we'll start to sum up a little bit. So we will be able to find the recording of this session on My AI, our platform. More information to come. Thank you all for this lovely session. I'm sorry that we have to end it a bit early. Take care and have a lovely day today.